The unseen burden, why dying without a will, places your children's future in peril for the vast majority of parents. The dawn breaks with thoughts centered on the day ahead, packing lunches, school runs, work deadlines, and the comforting rhythm of family life. Contemplating one's own mortality, or the harrowing prospect of leaving young children behind, is a shadow most instinctively push away. It feels unnatural, even macabre, yet the immutable truth remains. Life unfolds with unpredictable swiftness, rarely pausing for our preparedness. For parents who pass away without having executed a last will and testamenta, legal state known as dying intestate, narrative that unfolds for their most precious dependents can become exponentially more complex, distressing, and fraught with uncertainty than they might ever have envisioned. The immediate aftermath. One parent survives. Consider the scenario where one parent dies intestate while the other parent remains alive and retains legal parental rights. In this instance, the legal outcome is typically straightforward, albeit potentially unsettling depending on the family's circumstances. The surviving biological or legal parent almost invariably assumes full, uncontested custody of the children. This legal presumption holds firm regardless of the parent's relational status, whether they were happily married, legally separated, formally divorced, or even if the deceased parent had minimal recent contact. The foundational principle guiding the courts and child welfare systems is powerful and clear. Children belong with their surviving biological or legal parent whenever feasible and safe. The law prioritizes this biological legal connection above all other relational bonds in the initial determination. The catastrophic scenario, both parents are lost, or the survivor is unfit. However, the legal landscape undergoes a seismic and deeply consequential shift when both parents pass away simultaneously, as in an accident, or in close succession, or crucially, if the sole surviving parent is subsequently deemed by the court to be unfit or incapable of providing proper care. Suddenly, the profoundly personal question of who will raise your children, shape their values, and provide for their future is wrested entirely from the realm of your unspoken hopes and familial understandings. It is placed, instead, directly into the impersonal hands of the state's judicial system. At this critical juncture, your heartfelt desires, whether you always envisioned your devoted sister stepping in, trusted your lifelong best friend who has been a cherished aunt or uncle since birth, or believed a specific godparent was the ideal choice, hold absolutely no legal weight. Without explicit, written instructions, formally appointed within a valid will, the presiding judge is compelled to make this life-altering decision based solely on objective legal criteria and evidentiary standards, not on the depth of personal bonds or your intimate knowledge of who truly loves your children. The court's daunting task, finding a fit and proper guardian. The court then embarks on a formal, often protracted process to identify a suitable guardian. This involves meticulously evaluating potential candidates, typically starting with close relatives, grandparents, aunts, uncles, adult siblings, but potentially extending to family friends who petition the court. The paramount objective is to determine who is legally fit and proper to assume the immense responsibility of guardianship. This assessment is far from a simple checkbox exercise. It frequently entails comprehensive home studies. Social workers conduct detailed visits to the prospective guardian's home, evaluating living conditions, safety, stability, and overall suitability for raising children. Rigorous background checks, criminal history, financial stability, and child welfare records are scrutinized. Extensive interviews, the judge, court investigators, and potentially guardian ad litem, a lawyer appointed for the child, interview all parties involved, including the children if they are old enough. Contested hearings, in many cases, especially where multiple loving relatives or friends step forward, the process devolves into formal, adversarial court hearings. Competing petitions for guardianship are filed, Attorneys are hired, and individuals must essentially argue why their home is superior, often pitting family members against each other. The hidden trauma and the foster care gap, this legal machinery grinds slowly. What might seem like a straightforward decision can easily stretch into weeks or agonizing months. During this period of painful limbo, a reality most parents tragically fail to consider materializes. Your grieving children may be placed into temporary foster care. This is not necessarily or even usually because no loving family member or friend is immediately available or willing. It occurs because the child welfare system and the court require time to conduct their investigations, establish legal clarity, verify suitability, and formally appoint a guardian. The procedural safeguards, while intended to protect children, inadvertently create a perilous gap. Imagine the compounded devastation for a child, already shattered by the loss of both parents. In their deepest moment of need and vulnerability, they are suddenly removed from everything familiar, their home, their school, their pets, their neighborhood, and placed into the care of complete strangers within the foster system. This profound dislocation, this immersion into an alien environment driven solely by bureaucratic necessity, inflicts an additional, wholly avoidable layer of trauma. The confusion, fear, and profound sense of abandonment experienced during this transition can leave indelible scars, all because the essential paperwork, the clear, legally binding designation of a guardian within a will was not in place. The stark contrast. A will is an act of profound love, though. Difference between a future guided by a parent's deliberate choice and one dictated by impersonal court proceedings is immeasurable. Executing a valid will that explicitly names your chosen guardian and outlines your wishes for your children's upbringing is not merely a legal formality. It is one of the most profound acts of love and protection a parent can perform. It transforms heartfelt intention into enforceable legal reality, ensuring that during the darkest hour, your children are embraced by the arms you specifically chose to hold them, sparing them the additional anguish of legal limbo and potential placement with strangers. It silences familial disputes before they can erupt and provides the court with the unambiguous guidance it desperately needs to act swiftly in your children's best interests. Precisely as you envisioned. The financial peril, how intestacy robs you of control over your children's inheritance beyond the heart-wrenching uncertainty surrounding guardianship. Dying without a will unleashes a parallel crisis. The court's seizure of financial control over assets intended for your children. When a parent dies intestate, any property, savings, investments, or life insurance proceeds designated for minor children do not pass directly to them nor to a trusted caregiver you might have envisioned. Instead, these assets fall under the rigid supervision of the probate court. The court will appoint a guardian of the estate, often a stranger, bonded administrator, or a relative who must petition for the role or establish a conservatorship to manage these funds until each child reaches the age of majority, typically 18. The court's stranglehold on your children's funds, bureaucratic access, every dollar spent from the inheritance, whether for essential needs like healthcare, education, housing, or extracurricular activities, requires formal court approval. The appointed guardian must submit detailed petitions, receipts, and justifications for every expense, turning routine parenting decisions into costly, time-consuming legal proceedings. Need to pay for a child's emergency dental work or school field trip, prepare for paperwork, hearings, and delays. Inflexible management. The court-appointed manager operates under strict statutory guidelines focused on preserving capital, not nurturing a child's holistic well-being. Funds are often restricted to bare essentials, potentially denying opportunities like private tutoring, therapy, enriching travel, or even reliable transportation that you would have gladly provided. The lump sum time bomb, the most dangerous consequence, arrives when your child turns 18. At this legally defined moment, regardless of maturity, financial literacy, or life circumstances, the entire remaining inheritance is handed over in one unrestricted lump sum. Imagine an 18-year-old, possibly still in high school or navigating freshman year of college, suddenly receiving $200,000, $500,000, or more. Without structured guidance, this windfall invites catastrophic risks, reckless spending sprees, luxury, cars, high-risk investments, or predatory friends. Exploitation by financial opportunists or family members, derailed education or career paths due to a false sense of security, potential addiction issues fueled by sudden, unsupervised wealth. This abrupt transfer ignores a fundamental truth. Financial maturity rarely aligns with a birthday. Your child is handed immense responsibility with zero preparation is set up for potential ruin. The power you surrender without a will. Dying intestate means relinquishing all authority too. Choose the financial steward. You lose the right to appoint a trusted, financially savvy person, a sibling, best friend, or professional fiduciary who understands your values and your child's needs. Dictate the terms of access. You cannot stipulate that funds be released gradually, for example, 25% at 25, 30% at 30, the remainder at 35, tied to milestones college graduation, or used for specific purposes, a home down payment. Protect against external threats. You cannot shield assets from creditors, divorcing spouses, or poor decisions through protective trust structures. The solution: wills and trusts as shields of love. All these cascading tragedies, the custody limbo, the foster care risk, the court-controlled finances, and the lump sum inheritance disaster, preventable with a single, deliberate act, creating a legally valid will and establishing trusts. Here's how this simple step transforms your children's future. Guardianship clarity. Naming your chosen guardian in your will provides the court with an unambiguous directive, slashing delays, avoiding family feuds, and shielding your children from foster care, financial control, and protection through your will. You can establish a revocable living trust or designate testamentary trusts to hold and manage inheritance assets. Within this trust, you appoint a trusted trustee, not a court stranger, who shares your values and financial philosophy. Design custom distribution schedules, for example, education and health expenses paid directly, 1/3 of principal at 25, 1/2 at 30, remainder at 35 inches, closing parenthesis. Include protective provisions, for example, funds inaccessible to creditors, requirements for drug testing, or incentives for college graduation. Ensure professional management. If your trustee isn't financially expert, for example, co-trusteeship with a bank trust department. The ultimate act of parenting, planning for the unthinkable. Dying without a will isn't just a legal oversight, it's an abandonment of your parental duty to protect your children from preventable chaos. The court system, however well-intentioned, operates on impersonal statutes, not intimate knowledge of your child's heart, needs, or potential. It cannot replicate your wisdom, foresight, or love. Writing a will and establishing trusts transcends mere estate planning. It is the ultimate continuation of your parenting. It is a profound declaration. Even if I cannot stand beside you, I will ensure you are sheltered by the people I trust most, guided by the values I hold dear, and supported by resources released wisely, not recklessly. My love will still guard you long after I am gone. Do not let bureaucracy and strangers determine your children's fate. Secure their future emotionally, physically, and financially with the clarity only your written wishes can provide. This isn't morbidity. It's the deepest act of love you can inscribe.